And gentlemen, and thank you for joining us in the wake of the recent order that was rendered by the district court in Santa Fe yesterday. Yesterday's decision was, by all accounts, a historic moment, not only in New Mexico's fight to try and hold Meta accountable for the harm that they have caused to our kids, both in terms of facilitating exploitation and addiction, but also in terms of really changing the narrative in this country and frankly all over the world about whether or not companies of this size and scale can actually be held accountable. As you know, the decision yesterday rendered $567 million in damages for the public nuisance that was created by Meta's products and the direct impact that those products have had on the mental health of our kids. It is, in the judgment of the court, an appropriate remedy given the impact and the scale of this company and its activities, specifically in view of the fact that they knew about these harms, that they were not forthcoming about the danger, they were not honest with parents and policymakers and families, not only in this state but around the world. And so now they must pay the price for the choice that they made to put profits over children's safety. The court's decision lays out very clearly how the $567 million will be utilized by the state of New Mexico. By far, the largest category will be $420 million for treatment. That's to treat the kids who have been impacted by addiction and exploitation in our state, but also requires screening and assessment, awareness prevention, referral linkage and coordination, and implementation, quality improvement, and evaluation. One of the more interesting and unique aspects of the case that New Mexico brought, which differentiates it from other states and jurisdictions that have sought to hold this company accountable, is the degree to which we have conclusively shown that this platform is a breeding ground for predators. It is a place that facilitates not only hands-on abuse, but the identification and market-driven practices of child pornography. And one of the interesting elements and aspects of the court's decision was a mandate that this company work with us in real time and provide a real-time point of contact for this agency 24/7, 365. That has never occurred anywhere in the world, and it is, I think, a strong signal from the court about how serious the problem of child exploitation is on this platform. And I think it also highlights one of the elements that you will see not only in the compliance reports that Meta is expected to submit to the court in the coming years, but also some of the types of remedies that you will start to see in other states. I had an opportunity to talk to Rob Bonta, the Attorney General of California, last night. They have a trial date that's set for next month. As you all know, California, Colorado, Kentucky, and the other states that are part of that action have a substantially larger population. And we hope and expect that they will learn from our experience and make similar arguments about the requested relief and arguments about the size and scale of the harm that was created by this product. Nevertheless, there were aspects of the judge's order that I think should be a call to action for not only members of Congress, but also members of the New Mexico legislature. Throughout the order, the judge referenced opportunities that existed for both the legislative and executive branches to step in and provide more comprehensive guardrails for companies like Meta and social media generally. And I think one of the ways in which this specific decision should be interpreted is one that, while it is a victory, it is also something that highlights what comes next, what we must continue to do to advance this fight. And what that means is bringing forward comprehensive federal legislation and, in parallel, comprehensive state legislation. starting with real age verification. Now, the court's decision yesterday does impose new restrictions and age verification on the platform and on the company, but it also doesn't go far enough in our judgment. And there is also an opportunity to rely on and incorporate rapidly advancing and evolving technology into a proposed legislative solution, which my office will be presenting to the New Mexico legislature in the coming weeks. At the same time, while we are extraordinarily proud of the outcome that we obtained in this case, I want to remind everyone that the core statutory tool that was used, the Unfair Practices Act here in New Mexico, has not been amended in 56 years. We used a 56-year-old statute to hold this company accountable. Why does that matter? It matters because that statute was built for a totally different world. It was built for a totally different economy, and it didn't conceive of or understand or anticipate companies of this size and scale or the business practices that they engage in. And here's one very basic feature, which I think is easy enough for everyone to understand. The penalties that were assessed in the first phase of this trial, which yielded $375 million, had that penalty been indexed for inflation from 1970, that judgment would have been $3 billion. It's incredibly important for the legislature in the upcoming session to recognize how dramatically our world has changed, our economy has changed, and to update our consumer protection laws to reflect both the market power and the new way of doing business in the modern world. There are also substantial elements that touch on the types of business practices that we were able to address under the current law, but again, calls out for more immediate action. In other words, New Mexico has led the fight in the courtroom. Now we need to lead the fight in the legislature. We need to lead the fight in not only solidifying the gains that we have made in terms of holding this company accountable now, but setting out a blueprint for the rest of the country and frankly the rest of the world for how we expect businesses of this type to conduct themselves in our state and how we specifically protect our kids when it comes to social media. We will have comprehensive legislative proposals. We are already in active conversations and discussions with legislative leaders, and we are getting strong, I think, bipartisan support for a number of these efforts. But make no mistake, the same forces that were brought to bear against our case in the Santa Fe District Courthouse will be brought to bear even more forcefully in the legislature. This company has spent enormous amounts of money on lawyers and lobbyists and advocates and others dead set on stopping change, dead set on leaning into federal laws that were written 30 years ago that also haven't been updated as a shield to hide misconduct and as an excuse to abuse our kids. And what I think the jury's verdict earlier this year and the judge's decision yesterday points to is that there is a broad consensus in this country and in this state specifically that we can do better, that we can expect more, and that we will no longer tolerate a political system that is dominated by special interests, corporate interests, and this kind of big tech money driving our policy and in so doing endangering our kids and our families. That is where this fight goes next. It's something I'm committed to both at the national level and at the state level. And I think we have an opportunity to lead the way, just as we did in the litigation, now to do so again on the policy front. And so with that, I'll open it up for any questions that you may have.
All right, we'll start with questions in the room. As a reminder, please state your name and outlet.
Hello, my name is Nick Burke with KRQE. My first question, well, I have two questions. First question is, with the $567 million abatement fund, who will be distributing that money and how do those impact qualify?
So if you go back, these are the broad categories that the court identified, and it will be a determination that is made in part with policymakers and legislators in Santa Fe. Our role is to both secure the money and then ensure that the way in which it's expended comports and complies with what the court wants. But the New Mexico Department of Justice, our job is to win in court, recover funds, and make sure that court orders are honored. This will be the job of the executive branch and the legislative branch. The legislative branch to appropriate to specific programs that fit within these categories, and the executive branch to then facilitate and ensure that those monies are expended in a way that serves the ultimate purpose identified by the court.
All right, we have Michaela online. Michaela, can you unmute?
Yeah, hi, I'm Michaela with the Associated Press. We have a statement from Meta yesterday that says they're planning an appeal. I'm wondering, what is the likely timeline for implementing the safety measures outlined in the judge's order, and how could an appeals process impact that timeline?
Well, we have always anticipated an appeal from Meta. They have not shown any willingness to either accept responsibility for their conduct or concede that they have a role to play in fixing and addressing the harms that they created. In terms of what this means moving forward, we're going to have to do additional motions practice in front of the district court, and then obviously wait to see what specific issues they raise on appeal. We obviously reserve the right to appeal certain aspects of the court's judgment as well. And so I would imagine that process will take several months, if not years, to play out. But we will be pressing the court to order the payment of these funds as quickly as possible, and leave for the appellate court's judgments on maybe some of the injunctive terms and the injunctive relief. In our state, as in most jurisdictions, when a party appeals a judgment like this, they also incur the possibility of raising the total award, because interest accrues, and the time delay in distributing that money is also something that future courts will consider when it comes to how much money is ultimately owed. As to the broader question about whether or not they're going to be successful, I don't think they're going to be successful. If you look very carefully at Judge Beachide's order, he laid a very clear factual basis explaining why this conduct is not covered under their immunity arguments advanced under Section 230. He was very mindful of arguments related to the First Amendment. I think overall his judgment was somewhat cautious. There are certainly other judges in our state that might have taken a stronger approach to some of the injunctive terms that we laid out. But all of that is to say that restraint in his order actually makes the likelihood of success on appeal pretty difficult, I think, for Meta, and I don't ultimately think they're going to be successful.
Did the judge set any time limits for either the phase 1 or the phase 2 judgments to be paid? And would the appeal actually stop that or halt it temporarily?
Yeah, so the first phase and the second phase judgments are obviously something that are going to be subject to appeal, and the schedule that Meta will be required to pay will be determined both in post-judgment motions practice in front of the court and then through the appellate practice. So at this point, we don't yet have a firm timeline on when and how these funds will be distributed. In terms of the injunctive relief that has been ordered, which from my perspective is at least as important as some of the monetary damages that were awarded, I think our position would be that because of the finding of the jury, because of the ongoing harm identified by the judge, we are going to make a strong case and argument that those injunctive terms, those new guidelines and prohibitions on how they do business in our state, specifically not sending push notifications in the middle of the night, capping the number of hours that children can be on these platforms. From our perspective, those things should be implemented immediately, because the longer we wait, the more harm is done to our kids. And that is going to be something that both the district court and the appellate court is going to have to grapple with.
Raul, Jason McNabb with KOAT here. Your office originally asked for a 15-year abatement period. Of course, the judge ruled for a 5. How does that change things?
Well, look, I think it obviously compresses the amount of time that Meta has to comply with both the injunctive terms and also compresses the abatement period to a point where the distribution of these funds will match up with that new schedule. My sense is that we were looking for a longer time horizon, and that the court shortened that horizon in part because it makes it easier for judicial compliance and judicial oversight. One of the things that we had asked for that the judge didn't order was the appointment of an independent child monitor. I think that from my own perspective, a longer time horizon and the appointment of an independent monitor with real technical expertise would have been something that would make a lot of this process a lot more manageable. What I have said all along is that litigation is an important tool for bringing about the kind of change that we want, but it's also it has certain limitations. And part of those limitations are the fact that we are dealing with judges who may not have as much technical expertise as is required. And we also don't have the ability to adapt orders in real time. As most people are aware, and just in thinking through their lives, by the time we have identified a harm, dealt with that harm, and had an order like we have yesterday, technology moves forward, right? And the marketplace moves forward. And so what we need to do is to start putting more of an emphasis on the prospective side of the policy equation. And that means changing laws. There are a number of states in this country who have already adopted specific social media safety bills. And we are also adding to that this comprehensive rewrite of consumer protection. We think both of those things in parallel are as important as what finally happens with the time horizon on this judgment.
All right, we have Lauren online. Lauren, can you unmute yourself, please?
Hi, thanks for doing this call. Yeah, I wanted to ask if you would consider any cross appeal of this judgment in order to get more injunctive relief, and also if you could speak to what other AGs, other plaintiffs might learn from the places in the judgment where the judge declined to go as far as you would have liked, like on age assurance and encryption.
Yeah, that's a great question. As I indicated earlier, we are still in the process of evaluating the judge's decision to not grant specific forms of relief that we thought were necessary to make sure that our kids are safer moving forward. And we're going to obviously reserve the opportunity to appeal some of those elements. I think on balance, this is still an unprecedented decision, not only because it's the first time a company has been held not only liable for violations of our consumer protection laws, but also for creating a public nuisance. And that opens up an entirely new opportunity for other jurisdictions to hold them accountable. With respect to your question about age verification, this is actually the place in the opinion where I spent, when I was reading it last night and evaluating it with my team, it seems to me that the judge was relying on a pretty tightly defined understanding of the child safety and child privacy protections in federal law that were established back in 1996, specifically whether or not we could ask for verification measures that added up to 99% certainty. And it seemed as if if we went back and made this presentation again, and I would make this offer to my colleagues around the country, I think we would have been better served if we had offered up different ways of both identifying and verifying age, both for 13 and under and for 13 to 17. The other thing that was pretty apparent is that even in the time since the trial happened and the evidence was submitted to the court, there has been an evolution in the technological landscape, and you are starting to see more technology in development in terms of device manufacturers being able to obtain a signal about the user's estimated age and then providing that signal to applications who are required to sort of verify the age of people who are using applications. The reason that matters is that it gives us an avenue to address age verification without the burden of getting a government ID. It also satisfies, I think, this legitimate concern about privacy. And we are seeing more and more the use of what are called double-blind age verification tools, so that parents, in sort of cooperation, coordination with their kids before they set up their devices and phones, there's a way to identify whether or not an individual using that phone fits within a certain age range without disclosing private or personal information to the ultimate application. So I think building in a more flexible approach to age verification, one that accepts the legitimate concerns about privacy and then responds by using the absolute best and most up-to-date techniques for sharing age verification, is something that I'm going to be advising my colleagues around the country, because ultimately it's a false choice, and it is a false choice that was presented by Meta and is presented consistently in the industry, that you can't do age verification without violating privacy, right? And that was something that they relied on, again, in my judgment, a application of the Child Online Privacy Act. And there is a way to work through that to the extent that we can actually verify age without compromising privacy. And that's where that's where we need congressional action and state level action, right? If you read the court's opinion, he hinged this argument on a law that was passed in 1996. If Congress woke up and did its job and passed and updated a refreshed version based on the world we live in now and not the world we had in the 1990s, we could address these issues. We could address these concerns. But we can't address them as long as Congress and legislative bodies are sitting on the sidelines.
All right, we've got time for about 2 more questions. We're going to take one in-house and one online.
Yeah, Blake Trolley, KOB. A couple of questions. What do you really hope Meta takes away from this latest order for this payment? And on top of that, you describe Meta as having a large lobby, a really powerful lobby. Do you have any concerns that some of your legislative ambitions might get curtailed by a pretty aggressive lobby?
Yeah. So first, as to Meta, I frankly, given the conduct and character of its leadership, I don't expect them to do anything than they have done up to this point, which is to mislead people, hide the truth, deny responsibility, and delay paying for what they've done. So I don't have much hope that they'll actually change what they do, because ultimately somebody that has the power and wealth of a Mark Zuckerberg and the executives in that company, they could change all this right now. They could read this opinion. They could go into a boardroom in Silicon Valley and they could say, you know what, this is a moral call for this company to change the way it does business. But they've shown that they're not capable of that. The more important message, however, is for other social media companies and big tech companies generally, and I include in that artificial intelligence companies that are at the sort of the leading edge of a lot of policy disputes in this country. Americans of both political parties, of independents, Republicans, Democrats, rural, urban. Look, this is a deeply divided and polarized country, as I know well. But what I can tell you is this particular fight about not just whether or not our kids deserve to be safe online and in social media applications, but a larger political fight about why there are a different set of rules when it comes to rich, powerful tech companies that think they can go to a coin-operated Congress or a lobbying infested legislature and stifle all of this. They're swimming against the tide of history. The American people are tired of this, and they are tired of feeling like the system doesn't work for them. They are unequivocal about the dangers to their kids and their families. They're unequivocal about how they feel about their privacy. I have no doubt that Meta's army of lawyers and lobbyists will be out in full force in Santa Fe and in Washington, D.C. The truth of the matter is, though, we have to demonstrate that era is over, right? The Section 230 that they've been hiding behind, that was passed in 1997. The federal law that I was just referencing, that was first passed in 1996. They spend more on lobbying DC than any other sector in our economy. And that's why people wake up with this disgusted feeling that the government doesn't work for them. The government works for whoever can show up with a bag of cash at the White House or on Capitol Hill and get what they want. We're tired of that. Everyone's tired of that. And so this judgment, while it is against and about Meta's conduct in this state, there should be no illusions when it comes to the conduct of all companies of this size and scale and depth. If you do this in the state of New Mexico, we're going to have a fight. If you do this and you think you can hide behind lobbyists and lawyers, we're going to call you out. And I am personally going to lean on members of both parties on this issue to leave the fight behind, come together, and find a solution. That's the other aspect of this. People are tired of the forever partisan fight. They are tired of that. They want action. They want results. This is something that can bring Republicans and Democrats together. I have no doubt about it, right? I stood next to Josh Hawley in front of the Capitol. If you know anything about me and you know anything about Josh Hawley, you could not find two more different individuals when it comes to a whole range of issues. I'm a Democrat. He's a Republican. But guess what? When it comes to this, there's no daylight. So why don't we try in this country doing things in those limited spaces where we have agreement, just do the right thing. Just do what your constituents want you to do. Stand up for families and tell the guys with money and power and lobbying muscle, take a seat. We're going to do something different. That's what the American people want. That's what New Mexicans want.
All right, we've got one last question online. Dietrich from Reuters, go ahead and unmute yourself.
Hey, thanks for taking questions. You mentioned there's a lot of money, there's a lot of different injunctive terms. I just wanted to know if you could take the opportunity to name one or two injunctive terms that you think will make the most impact most quickly to protect children.
So I'll name a few. Number one, the way in which they deal with CSAM, with child sex abuse material. The court was very clear that what they do right now undermines rather than helps law enforcement, and their very clear expectations about cooperation and reporting. Number two, he set specific guidelines on AI-driven chatbots and the ability of chatbots to interact with young people. He set a hard cap on the number of hours that kids can be online on the platforms, and he stated very clearly that they have to do more to enhance their age verification tools within the current framework to make sure that they have a deeper understanding of especially those kids under the age of 13 and to delete those accounts in a way that will shield them from the most harmful content. All of those things those are historic things. Those are things that haven't happened anywhere else in this country, but it's just the beginning. And we have a lot more to do. I hope that's an important first step for us as a state, but it's only the beginning of a conversation nationally that we need to have around all of these issues to make this a safer space for all our kids and families.
All right, thank you all for coming, and this press conference is finished up.
Thank you.